As counsel in 124759, State of Kansas versus Becky Ann Wilson. Please come forward.
Good morning. May it please the court, the state of Kansas appears by Stephen J. Obermeyer. I'm an assistant solicitor general here to argue on this Becky Wilson case. Madam Chief Justice, may I please reserve 3 minutes for rebuttal?
3 minutes is granted.
Thank you. We are here this morning for what I heard earlier to be a conversation with the court and concerning something the court likes to do, and that is interpret statutes. We have 2 of them to look at and to review the Court of Appeals opinion as it relates to those statutes. Just briefly for the students' benefit, Becky Ann Wilson worked at Valley Hope, and while she was there, she was able to have checks sent to herself in the name of an LLC that she created in Kansas. She was able to obtain checks in the amount of $65,000, give or take. Based on that, she was charged with theft and fraud and convicted of that. She agreed to a controlling sentence. The state agreed to recommend probation. At the time of sentencing, the victim had asked for interest as part of restitution, and the court imposed restitution interest, and Becky Wilson went on her way until 23 months later when her probation was revoked for committing another theft while on probation and some additional violations. The first issue or the first statute that I'd like to discuss is the one dealing with extending probation, because at the time of sentencing, the pre-sentence report said that for counts 2 and 3, the recommended length of probation is less than 24 months. It would be 18 months for the second count and 12 months for the third count. This was stated in the pre-sentence report. The parties discussed the large restitution amount that she could pay $500 a month toward restitution, and the court placed her on probation and stated as to count 1 that it was for a period of 2 years. And as to the other 2 counts, the court stated it was placing her on probation for 2 years. There was no direct appeal from that, so nothing came up until the probation was revoked, and now it's a motion to correct illegal sentence issue, which is whether or not the court could have initially extended that probation to 24 months as opposed on the second and third counts as opposed to 12 months and 18 months. And I would direct the court to the KSA 216608, which has several subsections. Subsection C3 talks about except as otherwise provided for severity level 9 and 10 crimes, the duration of probation shall be 12 months. Subsection 7 has an except as otherwise provided, and that is when restitution is, if the defendant is ordered to pay full or partial restitution, the period of probation may be continued as long as the amount of restitution ordered has not been paid.
Is there a difference between being, that is important, between being originally ordered and continued?
I think the court can continue probation at the time of granting the probation, given the amount. Now, there's a case. I'm sorry.
Excuse me, I'll push back a little bit.
Okay.
And I don't mean to interrupt you,
Sure.
but the judge didn't know at the time of sentencing, although I admit, given how high this restitution was, but the judge didn't know at the time of sentencing that it would remain unpaid after 12 months or 18 months. So that's why I ask whether there's a significant difference between originally ordering it or continuing it when remains unpaid?
I think, given just that she was agreed to pay $500 a month toward restitution against the $65,000 amount, over the course of 12 months, at that amount, we're talking $6,000. Over 2 years, we're talking $12,000. So I think that's kind of apparent. And the cases, in the cases where this comes up, probation is extended during the course of probation. I was one of the attorneys on State versus Gordon back in 2003, where it got extended, and there's cases discussing how it's continued or whatnot. But I think when the statute says continued, that it may be continued, I think continued would be defined as extending without interruption. So the court, instead of having her come back, because she was in Texas on probation on an interstate compact, instead of having her come back in 12 months or 18 months, or just doing an order extending it, why could the court not just impose a 24-month probation right out of the blocks when she had her hat in hand, was very happy to comply with probation and pay restitution and do everything, didn't appeal that, saying you can't do that, to come back later and say King's X, you couldn't have imposed that probation, 24-month duration.
And the local rule did it automatically, didn't it?
The local rule said that if the court can impose its own conditions of probation, and it can choose to follow the Rule 717 rules. And the rule does, that rule, which the court followed, said that your probation will be extended for as long as the restitution is due and owing.
How specific was the court when imposing the restitution that this could potentially extend your probation for the rest of your life, as was made reference earlier this morning? Shouldn't that require some specificity on the part of the court to impose the exception under C7, which says we can continue probation as long as restitution is still owing? There wasn't anything specific that the judge made, was there?
No, the judge did not make any mention as far as how long she could possibly be.
Or even saying C7 applies here, and this is the condition that's gonna, in effect, put you in under probation and potential revocation for 10 years, 50, as long as it's still due and owing.
Right, and I guess
That's a pretty serious consequence, wouldn't you say?
well, but the judge didn't say that you're on probation and for as long as this restitution amount is owing. The judge set it at 2 years, and can revisit it at 2 years and see how you're doing, whether it should be extended, whether there's not a
That's not
likelihood.
exactly right, is it? I mean, as I read the order and the PSI, the judge ordered conditions of probation as set forth in the PSI or the pre-sentence investigation report. And that report included this phrase: the term of probation shall automatically continue without further court order as long as the amount of restitution remains unpaid. So isn't that effectively the judge ordering a probation period that extends into the future until the entire amount is repaid?
If that were the case, then I don't know why the judge would have said you're on probation for 2 years. I know it
Well,
did
that's
say
just
that.
because what judges do, they pick a period, but given what I've just read, I mean, do you disagree with
I,
my understanding of the record?
no, the record, the judge said 24 months. The record says you're on.
But the judge
on probation.
also said you are also bound by the conditions in the PSI. And this is what the PSI says. It says shall automatically continue without further court order.
Right. But,
I don't know how else to read that other than you're on probation until you pay this off.
and I don't know what the practice is in Norton County as far as what happens at 24 months, whether there's an extension done or whether they just rely on that condition. It didn't happen here because at 23 months, the motion to revoke was filed and the probation was revoked. And the judge did not mention C7. I think it was apparent to everybody in the room that there's this large amount of restitution and she could pay $500 a month. But if the court could, tell us what magic words the judge has to say if you're going to extend the probation beyond 12 months or 18 months on those secondary counts.
I guess I'm just wondering why your argument isn't just, well, that's exactly what happened. The judge did extend the probation.
I think at the time of sentencing, he did extend it. He said 24 months. The probation conditions
Why
said,
stop at 24 months?
I don't know what that judge's practice would be, whether it would just,
Why do we need to know the judge's practice when we have words that say automatically continue without further order?
I guess you don't need that. I'm just going based on what my experience was, having had those type of cases. And yeah, the judge didn't have to say 24 months, could have just said you're on probation for as long as the restitution is due and owing. And I guess that would have been clearer.
And,
Yeah.
and the, go ahead, go ahead.
A couple one cleanup thing and then one hypothetical. If she's still paying restitution?
I filed a Rule 2.042 letter recently stating that she's been released from post-release and is no longer under any sort of sentence. So
So that means she's not paying restitution anymore?
well, she's no longer, she got revoked for this and went to prison and finished post-release. So I don't think under State versus Arnett that she could be ordered to pay restitution.
It still just hangs there on the books. If she pays it, it'll be lower, right? I mean, she can still pay it to the court, but she just can't be revoked anymore.
Well, she's not on probation anymore.
Right, she's not on probation. I guess she could pay it. I've never seen that, but she could.
Okay, so when we decide this case, we still decide it under the facts in the record, or are we deciding it under the general mootness that, it's capable of repetition, excuse me, and raising concerns of public importance?
That's what I think, that even though as to Becky Wilson, I consider it moot, this is an important issue that arises frequently when you have large amounts of restitution and
Why is it moot as with respect to the defendant? It still is a liability that attaches to her, even if it's civil only.
I thought State versus Arnett got rid of any liabilities that.
Well, it got rid of the judgment portion of it, but
It may still affect whether or not she's able to get this charge expunged. I mean, they're gonna look at this record and say, well, you've still got $18,000 of restitution that you haven't paid. And, so there are consequences that still may happen with unpaid restitution. Do you know that it's still unpaid?
I don't think there'd been anything filed in Norton County in that case for a couple of years. So I don't think that there's been any restitution payments made. And as to I'll just say as to the interest issue, I just don't want to see an opinion that states interest can never be ordered as part of restitution. I think in this case, the victim had a bank account that the money was taken out of. So, and these facts weren't developed, but the concurring opinion talked about a scenario where interest could be ordered. Now, not the statutory interest that the judge did in this case. And I would agree that that would not be appropriate and that interest part would be stricken, but
This case.
in this case, the judge did it incorrectly. It should just be the restitution of $66.8 thousand.
Which gets me to kind of my hypothetical.
Okay.
What if we determine that the court did not support the order to pay interest with appropriate factual findings? Trying to figure out whether because she's out of jail and there's no issue there anymore, or be precluded from vacating it because you had your bite at the apple and feed, or are you asking to vacate to go back and make those kind of findings? I don't know what to do with that part of
Right,
it. That's why I'm
right.
asking.
The way the sentencing judge couched it, kind of interest at the statutory rate, I think that would be wrong, and that there should have been a hearing on what the victim's interest, how much the interest should have been, how much they're out from the money in the bank account and so forth. So as far as what you do with that, I don't think it'd be worth remanding it to have the judge make these findings on a case where the sentence is being completed.
There's just not substantial competent evidence of that loss, is there?
There's not, but, and the part of the problem is this wasn't directly appealed, where this isn't a direct appeal. This is a collateral probation revocation appeal where the issue is a legal issue being raised under a motion to correct a legal sentence. And the issue is, can interest be part of restitution? At least that's how I see this case. And I think just like insurance premiums or travel expenses, if part of the loss caused by the defendant's actions is a loss of interest, then that could be ordered as restitution. And I know that won't apply as to Becky Wilson's case.
I'm going to take us clear back to interpretation or construction of the words of the statute.
Sure.
Because we really haven't talked about the four words has not been paid. So it may be continued, and the argument, of whether does continue mean extend, or does it mean you can impose a longer term originally, as long as the amount of restitution ordered has not been paid. How do you sentence somebody for months that would be beyond the allowed time prospectively, when the conditional words has not been paid?
How do you sentence?
How do you say, if your probation is supposed to be 12 months, how do you say on the date of sentencing, your probation is supposed to be 12 months, but I'm going to sentence you to 24 under this provision? Because at that time, you don't know that in 12 months' time, that restitution has not been paid. Don't those words almost mandate that this be read as an extension of probation time rather than an original term of probation?
The statute says the period may be continued as long as the amount of restitution ordered has not been paid. And I don't think it was on anybody's radar that she was going to pay $65,800 within 12 months or 18 months or 24 months. I think the judge said it at the 24 months, so let's revisit this and take a look at it. But there's no way to tell. And I guess if she'd, won the lottery and paid it all off the next day, would her probation, I don't think her probation would have ended. I think it would
Well,
still
that's the-
been.
And that's the problem. I mean, because that condition, he's imposed a term based on what they predict the condition to be. But can that legally be done?
I think under that language in C7 that it could be continued for 24 months at the outset, and you don't have to come back and bring her back in court and do it in 12
Well, why?
months.
Because I thought I just heard you say that if she pays off restitution in month 13, now she's stuck on probation for 11 more months.
I think so. And
That legal?
she could come back in front of the judge and ask.
Why
her-
should she have to do that? I mean, how is that a legal term of probation?
I think it's legal because subsection C3 says, except as otherwise provided, you're on probation for 12 months. So C7 says, if you owe restitution, you're on probation until it's paid off.
And she pays it off in my hypothetical in month 13. She's still under an order of probation.
I think she is for 24 months, and she'd have to file a motion to terminate, early termination.
Well, the most serious charge carried 24 months.
Correct.
Right. So I've been struggling with that too. And I think that perhaps the judge really made two orders. One may or may not be valid, that it's 24 months on all three charges, because one's 18 and one's 12. But he also said it was subject to local rule. And the local rule says if your restitution isn't paid, that your probation is extended. So is that both then?
I think it could have been extended under continued at the time of sentencing for 24 months under C7 or under Rule 717 that probation continues as long as I think both of those could have applied.
So
to this.
the local rule in effect was towards the end of 12 months, well, it's not paid, so it's automatically extended. At the end of 18 months, it's not paid, it's automatically extended. It left those lesser sentences live as possibilities for revocation.
That's what the local rule say. And the Court of Appeal seemed to hold fast to this C3 that it has to be 12 months. Well, you have two different subsections, and if you look at them, the more specific subsection, I think, is the C7, if you owe restitution, and that should control over the subsection C3 that says except as otherwise provided, and that and the Rule 717. And if she hadn't had energy about that at the time of sentencing, she could have said, you can't do that. So we're basically here as a motion to correct the illegal sentence. Could the court have gotten to 24 months if it said the right words at sentencing? And I think it could have done that. That was the elephant in the room was the amount of restitution, and she could only pay $500 a month. I see I'm out of time, so unless the court has any other questions. Thank you.
Thank you, Your Honor. Becky Wilson appears through counsel Casper Shire, Kansas Appellate Defender. I think I'd like to start by talking about interest. And I think I hear the state conceding at this point that a forward-looking order to pay 12% interest on unpaid restitution is not lawful. And certainly we would agree with that. And I want to make clear exactly how this restitution order came about.
I understood him to say it wasn't proved. The loss wasn't proved in this case, that's what he concedes.
Okay.
Not that it can't be forward-looking if it's proved, but that it wasn't proved in this case. That's what I understood.
Well, maybe I
Perhaps that's-
misunderstood, and that's he'll have a chance, I suppose, to come up here and clarify exactly what he meant. Either way, I think the way we got to this restitution order is very important. This was part of a plea agreement. Both parties agreed that $65,000, give or take, was the appropriate amount of restitution here. And that is how the court arrived at a $65,000 restitution award. There was no evidence because everyone agreed this was the restitution. So to get back to the question that you asked about remedy, Justice Biles, the state doesn't get a second bite at the apple here. And the name of the case eludes me, but I think that is essentially what this court has said in a fairly recent case, which is that you go back based on the evidence that was presented originally. And here the evidence presented originally is we both agree that $65,000 is the correct restitution amount. We do maintain that a forward-looking order of 12% interest on unpaid restitution amounts is unlawful and is an illegal sentence. There are, first of all, this court made clear in our net that restitution is not a civil judgment. That cannot be squared with what the district court ordered here, which is the Becky pay interest on this restitution amount forward-looking, quote, at the rate that would apply to a civil judgment. There's nothing.
But
in
if it were the interest rate being drawn on their bank account, for example, if that was the evidentiary showing in a case, would that be a permissible order for restitution?
I think potentially it would be, Your Honor, but that's a situation totally different from what we
Correct.
have here.
Right. I just was trying to clarify whether you're saying that the statute itself would not permit that or just factually here. It could
No.
not be.
What the statute doesn't allow is a forward-looking 12% interest payment on unpaid restitution. The same way that you could not order a 12% forward-looking interest payment on, say, bids attorney's fees. And the reason you can't do it is because there's no statutory authority for it.
I kind of want to get to the mootness issue. So does she still owe restitution? I mean, is it on the books still?
I have seen nothing showing that it's not, Your
Okay.
Honor.
So, but there's no way to enforce it. It's just out there, right?
It's out there. I have seen no indication that it is enforceable or it isn't. I just don't think we have any indication of that at all in the record.
And so a decision today, on interest, would you agree with your colleague that it is, of statewide, capable of repetition and raise concerns of public importance?
I think I would agree with that, Your Honor, but I would also point out that while Becky was on probation in this case, she racked up $15,000 worth of interest that she became responsible for. And again, as far as I know, that's still on the books. I cannot tell you what kind of efforts might be made to collect it once her sentence is done, but it's still out there. So I don't think this is a moot question.
Okay, and then what about the claim that her, to the Court of Appeals, that her original probation for the severity level 8 and 9 illegally exceeded the statutory terms? Is that moot?
It was
Because-
not,
Yeah, go ahead.
no, I'm sorry, Your Honor. It certainly was not moot at the time this was briefed
Right.
to the Court of Appeals. I don't see subsequent developments as a reason to invalidate the Court of Appeals opinion on that basis. But it does appear that she served every day of her sentence, and, our position is certainly, a lot of those days were illegal.
Understand something you said, which was that at the time you argued the case to the Court of Appeals, that the probation period, and here's my thinking, on the two lower ones, didn't those go away as soon as the court, whether that was a proper 24-month probation period on those lower offenses, didn't that issue all go away the second probation's revoked? Just at that moment? Because once it's revoked, it's revoked.
That's true, Your Honor, but the underlying sentences were ordered consecutively. So she served prison time for the secondary counts. And she was in prison serving that time when we briefed this issue to the Court of Appeals. Consecutive underlying sentences, not consecutive
Yeah,
probation.
I just didn't connect that dot.
But those sentences have already been served.
They have now, Your Honor. I'd like to return to one other point on the probation length issue, and we talked a lot about subsection C7, the extension, the unpaid restitution extension. And I'd like to highlight two things about that statute. First, if you look at subsection C6, it provides an absolute 5-year cap. In most cases, there are exceptions, but an absolute 5-year cap on how long probation can last, except as provided in subsection C7 and C8. And then subsection C7 lays out the unpaid restitution exception. So C7 does not look back to the original term of probation ordered. It looks to the total probation length, the cap on total probation length. The only subsection that allows a district court to order a longer term of probation at the outset is subsection C5, which requires particularized findings. And this court has looked at very similar language in the probation revocation context and said that particularities findings means something specific, something concrete, something we can't sit here and infer the reasons why the judge might have done this, which seems to be exactly what the state is asking this court to do, is to infer that there are reasons why the judge might have ordered a longer term of probation. We can't do that when the statute requires particularized findings.
What is it specifically that you're asking for here?
We are asking for the interest portion of the sentence to be vacated. And we are asking for the sentences imposed on the secondary counts of conviction to be vacated.
Say that last
And
part
is
again,
that-
I'm sorry.
Is that, sorry, you go ahead and
Just-
then I'll follow up.
Just repeat that last part. I was writing a note on first thing you said and I missed the second.
The sentences imposed for the secondary counts of conviction be vacated.
And then my follow-up is that seems like it maybe is not what we ordinarily would do when we find any illegal sentence. Typically, we would remand for resentencing.
Yes, that's true. So maybe if a remand is appropriate here, though, Your Honor, I think it would be a remand with orders to vacate the forward-looking interest and to vacate the sentences imposed on the secondary counts of conviction. So it's, maybe I missed a step in there, but I don't think the ultimate remedy that I'm asking for changes.
And by vacate the sentences imposed, you mean the original sentences imposed?
Yes, because Becky finished the lawful term of probation on the secondary counts when she hit the 12-month mark and then when she hit the 18th month mark of her probation.
So essentially, that she would be resentenced to the time she already served, essentially is what we're talking about. But it does change the factual record of what her, what her convictions and sentences were.
And certainly the interest part of it, that order that she pay interest and, the interest that she racked up while she was on probation is still out there in some form or another. And certainly we think that needs to be fixed.
And I get that part on the interest. I'm still having trouble understanding why you're helped if we vacate those. Aren't we all sort of done?
Becky has served the
Right or
time.
wrong?
No,
Done.
I understand. Becky has served the time. At the end of the day, like I said, these issues were not moved when we briefed this. Becky was still in prison. We briefed it to the Court of Appeals. The Court of Appeals resolved the issue, we believe, correctly. And so I guess what we're also asking for ultimately is that this court affirm the Court of Appeals on that point. They've reached the right outcome here.
Apparently, she was revoked because of the possibility she committed new crimes. At least that's what I infer was found at the time of the revocation hearing. Did that ever cause her to serve additional time that may have been tacked on the end of this sentence, or is that just going way out there in speculation land?
It's certainly not in the record, Your Honor.
And she's been released, so.
Yes. Yeah, I think the short answer is I don't know. Unless this court has further questions, I'll conclude just by asking this court to affirm the Court of Appeals, to hold that district courts cannot order forward-looking interest, particularly not, at interest rates that seem to be plucked out of thin air, to individuals who are ordered to pay restitution. to endorse the reasoning of State v. Baker, which is what the Court of Appeals relied on to vacate the sentences on Becky's secondary counts and generally to affirm the Court of Appeals here. Thank you.
May it please the court. Justice Wilson, I don't know if you were asking what happened to her in Texas on the Texas case or not.
I was, because if it may make a difference as far
Right.
as when she starts that sentence.
Right, I think that is in the record at the revocation hearing. She paid $8,000 and got released, basically. She didn't have to serve any time in Texas on that case. With regard to interest, it either wasn't proved. The way the judge wordsmithed it was incorrect. It should have been interest as part of restitution. But I agree it was incorrectly handled, but I still think that interest can be an element of restitution, given the facts of the case, and that the Medicaid fraud statute did not, just the fact that the word interest appears in the Medicaid fraud statute, that doesn't mean that some future victim can't get interest as part of restitution if it's proved to the district court.
Are you conceding then that a failure of proof equates to an illegal sentence?
No, I'm not. However you want to get at the fact that the Court of Appeals couched it as an additional fee or something like that. There was no restitution hearing requested. But no, I would not say it would be an illegal sentence if it's just because it's not proved. And I think in the supplemental brief, I
The
cited.
state's position is that this interest award was incorrectly done, but doesn't render the sentence illegal.
Well,
But correct me if I'm wrong, this is all under the umbrella of an illegal sentence.
right. The way the sentencing judge couched it, it was not part of restitution. The judge said the restitution 65,000 and then you owe interest on that. And as opposed to how you would include interest as part of restitution.
Okay, so you're conceding that this portion of the sentence didn't comply with any applicable statutory guideline because it wasn't even part of restitution.
As far as the interest, yes.
The interest only, that's what we're talking about.
Yes.
Okay, now
Yes.
I understand. Thank you.
Yes, that's sorry that I worded that badly. The State versus Baker, the Court of Appeals reliance on that doesn't apply at all because it doesn't even mention subsection C7 at all. And and under C5, you have to have specific findings for public safety or welfare or inmate welfare. But you don't have to have findings for C7. And I think it was obvious. And I mean, tell us what district courts have to do at sentencing if you want to extend a 12-month probation beyond that.
Well, how about just say that? I mean, I understand the pre-sentence investigation refers to the local district court rule that is stricter. It says shall instead of may, which
Right.
C7 says, but what's wrong with saying uttering about 5 words?
Nothing. I mean, I think the judge could have said that. And I cited in the supplemental brief, the Kingsley and Pirano cases, which basically say if it's not an illegal sentence as far as how you get there, if the court could have imposed a 24-month probation, if it said the magic words, the fact that it didn't doesn't make that an illegal sentence. So given that and the Rule 717, the local rule, I think it was proper for a 24-month probation on all 3 counts to be imposed. And would ask that that the district court be affirmed on that. Thank you.
Thank you to both counsel for your arguments today. The court will take this appeal under advisement.